Hi, this is Jonathan Rubens, Editor-in-Chief of Business Law Today. Welcome to our ongoing series of Spotlight interviews. This is one of our program spotlights where we feature some of the content going on at our CLE programs live from one of our meetings. Here we are in Austin, Texas, and I'm pleased to have with me today Alicia Downey and Chris Young. Sorry about that, Chris.
Sorry.
Who just came from a program that they both helped organize. And the program was put on by the Antitrust Committee of the Business Law section, and the title of the program was Labor Pains, Antitrust Challenges to No Poaching and Non-Solicitation Agreements. So to start us off, tell us about the program and what it involved.
Thanks, John. This program was one of 3 antitrust-focused programs that the Antitrust Law Committee presented at this meeting. We had a 2-hour antitrust update that we do annually. We had that this morning. We had the 1-hour session that Chris moderated on no poaching agreements. And then tomorrow we've got another session that focuses on antitrust treatment of digital technology, very cutting edge. So things like blockchain, algorithmic pricing. No poaching in particular is also a very timely topic, and we were very glad that we were able to present that. Chris was able to assemble an excellent panel, including a representative from the DOJ who spoke about what the enforcement actions have been. So I'll let Chris talk a little bit more detail about that.
Terrific. Sure. And I'm so pleased that we have all this antitrust content going on at the meetings. It's great.
Yeah.
When I look at a title like this and I see non-solicitation clauses, the first thing that I think of is things like non-solicitation clauses and agreements that I have with my clients with their employees or with people they're hiring. But here we're talking about something else. When we talk about no poaching clauses, we're talking about other kinds of problems between companies and between businesses. And as I understand it, there's been some pretty significant recent case law around this. So I guess you can tell us some about that.
Sure, yeah. What we're talking about is a different context with antitrust law and the different way you look at it, not from an employment point of view, but how antitrust law analyzes labor and employment issues like this one, no poach agreements. And like Alicia said, we had a great panel. We had a DOJ lawyer from the Antitrust Division who's been involved in no poach enforcement actions. We had a lawyer who has a plaintiff's practice who's been representing a number of putative classes, employee classes against large franchisors like McDonald's. And we also had a lawyer, Adam Finacki from Canada, to talk about how these provisions are treated in Canada.
And it turns out they're not.
They're not, right. And I came to the panel as a moderator, but also as from the employer, more defense side on antitrust. So we had essentially, I'd like to think we had most of the perspectives covered on a topic that Alicia also mentioned is very topical because recently, although these provisions have been challenged for a number of years in other industries like entertainment, high-tech, healthcare, hospitals. Recently, in the fall of 2016, the Department of Justice Antitrust Division issued HR guidance, or guidance for HR professionals, in which they said that they would treat what they call naked no poach agreements as criminal violations of the Sherman Act. So that got not only HR professionals but business leaders' attention. President Trump's first Assistant Attorney General for the Antitrust Division, Malcolm Delrahim, also came out and reasserted that he would, and this was I think last fall, that he would that they were investigating these and it would be investigated criminally. So on top of that, you have state attorney generals issuing subpoenas to a number of fast food franchisors, and you also have a political aspect to this topic as well, which is that Senators Warren and Booker have introduced bills in Congress seeking to make an absolute prohibition on no poach agreements at all.
Yeah. Backing up, can we, just for point of clarification again,
What
so
is a no poaching?
Yeah. What is a no poaching? And from what I understand, these kinds of clauses are very, very common, certainly in the franchising context, but presumably in other kinds of contexts between other kinds of businesses as well. So what would be the definition of a no poaching clause? And when the antitrust division says, I don't know if it's their phrase or yours, but they're going to try to hold naked no poaching clauses unenforceable or unlawful in certain contexts, what do they mean?
Sure.
So what's the definition?
So a no poach agreement is an agreement between, in the antitrust world, it's agreement between two competitors or two businesses not to hire, solicit, recruit, or poach each other's employees. And they exist in a number of different agreements. For instance, I think where they exist the most is in mergers, where two competing firms agree to merge, marry up, but before doing so, they enter into a non-disclosure agreement in which they're going to exchange information. They also expose their employees to each other. So the seller wants to make sure that the buyer doesn't take all the employees if the merger doesn't go through. So that's what's called an ancillary no poach agreement. And it's a routine agreement that's entered into all the time. A number of my partners, when these the headlines hit on these the HR guidance and the other comments, were very concerned because that was something that private equity lawyers, corporate security lawyers deal with all the time, and it's routine.
Of course, and I'm sure a lot of lawyers at this meeting are very concerned about this topic because in the M&A context, in that interim period, in the diligence period, or in the pre-closing period, they certainly rely on their NDA agreements, and I see them frequently, NDA agreements that include certainly non-solicitation language, if not no poaching language.
I don't think you're going to see that's an issue. The real concern, the reason antitrust law is interested in this is it's ultimately a form of wage fixing. It's a price fixing. Everybody's colluding to keep wages down or stable, and when there is no, a pro-competitive purpose, when it really is just an agreement for the purpose of keeping wages down and keeping, eliminating employees' bargaining power, that's when you're looking at some of the criminal implications.
So just to be clear, do we or do we not think that this has implications for the M&A process that are of concern?
No, the answer is no. In the sense, as long as in what we're talking about, non-disclosure agreements related ancillary to a larger collaboration between competing firms, and so long as the terms of that non-solicitation or no poach are reasonable. In other words, it's protecting the solicitation of management employees, engineers, those types of employees, and not everybody, and that the restriction isn't forever, which they typically aren't.
Right.
So typically they are structured to the need, the pro-competitive need, so it shouldn't be a problem. Where they're running into issues today are the quote-unquote gentleman's agreement among competing firms, that it'll get too expensive for us if we keep poaching each other's employees, so why don't we, wink, wink, not do that. Yeah. That's a naked no-poach agreement, which is what the antitrust division is looking at criminally, and they have gone after folks, not criminally yet, although at our meeting today, the antitrust division lawyer did indicate that we may see and hear about criminal indictments shortly. So it's a serious issue. And one thing I just wanted to talk about to bring it around to the franchise.
Sure.
When we talk about the franchise agreements and why that's an issue is because in the franchise world, you have a franchisor who has agreements with hundreds, if not thousands, of franchisees.
That's right.
They're pretty uniform agreements that aren't typically negotiated, and they have no poach provisions there. And in that context, what you're talking about are provisions that say franchisee A agrees with the franchisor not to hire, solicit, recruit, or poach not necessarily the franchisor's employees, but franchisee B.
That's right.
And that's the challenge, and it presents a lot of interesting legal issues from the antitrust perspective, which I think we're going to see resolved in the next year or two, as to whether, what's the standard for assessing those kinds of agreements? Is it an agreement, a horizontal agreement between competing firms, or is it a vertical agreement, which you get a lot more leeway from?
And right now, we don't have enough clarity on that point.
Correct.
Although,
Well, I think the defense lawyers think it's very clear. I think the plaintiff's lawyers think it's also very clear.
yeah. And but there have been a couple recent cases that touched on this very issue, which I gather were just addressed in the program.
There
Do you
were,
want to
yes.
tell us just very quickly what the cases are in case folks want to dig deeper into this topic?
Sure. Do you want me to handle that?
Well, I mean, just broadly speaking, and then I'll turn
sure.
it over to you. I think the reason there's been a lot of government enforcer interest in particularly the franchise context is a lot of these employees who are affected by it are low level, and they find themselves unable to get jobs within a franchise system that they're familiar with. So in order for them to work, they've got to either go to an entirely different franchise system or find another job. And so that is perceived by people at the state level as being quite unfair. The employees never agreed to these restrictions, but they are perceived as the victims. So I think there's a lot of political will toward
Sure.
eliminating them for that particular class of employee
Right.
in the franchise world.
Sure.
And as far as where the litigation stands right now, there's probably 7 to 10 active lawsuits right now around the country.
Specifically in the franchise context.
Specifically franchise. McDonald's was sued in Illinois in Chicago federal court. Jimmy John's was sued in the Southern District of Illinois. Pizza Hut was sued in Dallas, federal court in Dallas. Carl Jr.'s was sued in state court in California. Little Caesars was just sued in the Eastern District of Michigan.
And these are all lawsuits addressing the no poaching issue
In a franchise.
in the context of the franchise agreement.
Correct. The one that's furthest along is McDonald's. And the court just got through the summer, issued an opinion on the motions to dismiss. McDonald's argued that it was a vertical arrangement and should be considered under the rule of reason. That's a summary of their arguments. They made a number of others, but that's a general gist of what they were arguing. The court, it forced the court to analyze whether what standard to use, because the plaintiffs did not bring a rule of reason case. They claimed that it was per se illegal. The judge in the McDonald's case found that it was a horizontal arrangement, a horizontal restraint, because of the fact that McDonald's had company-operated stations, but found that it would not, even though it was horizontal, there were some pro-competitive output-enhancing aspects of the agreement that he wouldn't look at it under a per se as per se illegal. But he didn't go to rule of reason either. He decided that it's more than likely to be a quick look, which is a more rare used, seldom used standard.
Right.
And it could change, but that was his preliminary opinion. What I think is interesting in that case and is worth looking at is that McDonald's did make the argument that in dual distribution systems, even where the manufacturer competes with the dealer, that doesn't change whatever agreements that the manufacturer and dealer have from vertical to horizontal. And there's some good law on that in the Seventh Circuit. So that'll be an interesting one to watch to see how the courts grapple with it. And one last thing to mention in California, the judge in the Carl Jr.'s case, which I believe is in Los Angeles County Superior Court, had a preliminary hearing, or might have even been a status hearing, and he looked at it and said, geez, how am I supposed to decide these issues? They're complicated. You guys have to go out and get experts, and the experts have to come back and tell me what to do.
Okay.
So that just gives you a sense of
Yeah.
that these are, it's different than it's presenting different novel legal issues that the antitrust law hasn't dealt with directly. So it'll be interesting to see how the courts come out.
Absolutely, and we'll be looking for further information from these cases, certainly with regard to this analysis of the vertical relationships versus horizontal, and these other things you were just describing for us. To finish up, it's so interesting that we're sitting here talking about antitrust law, that that the committee is putting on at least 3 events here at the fall meeting, and 10, 15 years ago at a meeting, we wouldn't have had a lot to talk about in the way of antitrust law. It seems like there's an uptick in interest, in activity. Am I wrong? So tell us about just overall what's happening in the antitrust world and why people should start to pay attention again.
You just have to look at the newspapers. Google, Facebook, Apple, and antitrust seems to make some sort of a headline every other week. I think people are looking at whether antitrust laws are going to be able to help address sort of the effects of big companies and their perceived dominance, in various different markets. I think that with respect to the no poaching, state and federal enforcers are using it as a tool, I think, to sort of protect. They would tell you they are trying to protect workers, who really have no other recourse. And so, it's making itself known in a lot of people's daily lives. On the business side, though, in terms of transactions, our antitrust update pretty much summarized things. I think it's business as usual for the most part. There have been no earth-shaking changes in the legal standards. Merger reviews are still, very active. No more so in Democratic administrations than they are in Republican administrations. So on one side, there's very little to report, but it's kind of how is antitrust going to be helpful or not in the face of new ways of doing business and high technology.
Sure. Well, I'm sure.
I think Alicia hit the nail on the head. And one thing I just wanted to mention really quick was because I went to the Alicia's presentation this morning on the antitrust update. And what I found fascinating was that the issues that antitrust law needs to deal with, for instance, is the algorithm.
Oh, algorithmic pricing. That's
Algorithmic
going to be a household
pricing.
word pretty soon. Algorithmic pricing.
That's a great example of, it seems like the law hasn't changed, but what the law has had to do is pivot and adjust to new industries,
Absolutely.
new technology. And when you talk about people pricing through algorithm calculations and using programs and not themselves sitting in a smoke-filled room making arrangements with competitors.
Yeah, one person used the words robot collusion in their slides.
Technology has its hand in everything.
It does.
Technology can collude as well as people. Well, thank you both, Alicia Downey, Chris Young, for organizing this terrific program with the Antitrust Committee and for joining us here today. Thanks to all of you for watching this program Spotlight, and look for more on the site, businesslawtoday.org. Thanks.